A wife, a mother, and now an accused predator. 44-year-old Sarah Jean Sellers is facing 80 child sex charges, including statutory rape. Authorities in Brunswick County, North Carolina, arrested Sellers on Valentine's Day following a lengthy investigation into years of alleged abuse. Sellers is accused of sexually abusing multiple victims. Prosecutors revealed in court that two of the victims were allegedly just 12 years old when the reported abuse began, and more potential victims could be on the way. I'll break down this story for you. For Law and Crime News, I'm Kennedy Walker. Sellers was taken into custody on Valentine's Day, a day meant for love, now marking the start of her fight against shocking accusations. Instead of celebrating with her husband of 22 years, she was booked into the Brunswick County Detention Center, where she remains behind bars. But first, let's take a deeper look at who Sarah Jean Sellers is and how investigators uncovered the shocking allegations. If you take a look at her Instagram, she looks fairly normal. Her social media is filled with more than 200 pictures of her family, complimenting them, showing off their accomplishments, and sharing moments that seem to paint a picture of a loving wife and mother. But behind the celebratory and proud posts is a woman charged with 80 counts of child offense charges. Here are the details according to the Brunswick County Sheriff's Office, and I must warn you, the allegations are disturbing. According to WWAY News, the state revealed that all of her alleged victims are boys, two of whom were 12 years old at the time of the alleged sex crimes, which spanned from 2018 and 2019. Two others, whose ages were not specified, are currently interviewing with detectives. Sellers faces 20 counts of statutory rape of a child under the age of 15, 20 counts of indecent liberties with a child, 10 counts of statutory sex offense with a child by an adult, 20 counts of statutory sex offense with a child under 15, and 10 counts of statutory rape of a child by an adult. And joining me to talk more about this story is legal expert Safa Robinson. Safa, thank you so much for coming on today.
Thank you, Kennedy.
So let's just dive right in. Based on the charges against Sarah Jean Sellers, what kind of sentence could she be facing if convicted?
Ms. Sellers is charged with a number of charges, specifically 80 counts of sexual misconduct charges against herself. She's looking at spending anywhere from 15 years to the rest of her life in prison for these charges.
Wow. What does it take for prosecutors to even bring 80 child sex charges against the suspect?
What oftentimes happens in cases like this is there's an initial disclosure. There's a disclosure by that child to someone who is either a family member or presumably a mandated reporter. These things happen either, the disclosures can happen at school, they can happen to a parent or anybody that would essentially be a mandated reporter. They then report to law enforcement what the child has told them. The law enforcement will investigate. Oftentimes they'll do what we call a forensic interview and forensic examination with respect to that particular child. They are, performing a rape kit if it's anywhere short in the time that these allegations have taken place. Not only that, but they are interviewed by law enforcement. In New York here, we have certain entities that are in place so that the child can tell the story one time or as minimal times as possible. You have attorneys that are viewing this. You have social workers, caseworkers, and things like that. They are oftentimes being interviewed by caseworkers and social workers. Those individuals are asking the appropriate questions that would essentially substantiate the charges that law enforcement is essentially looking to charge that particular individual with. And if that child discloses certain activity that would fit, again, for example, in this case, statutory rape, then charges will be brought against that individual either by law enforcement or by the district attorney's office or by both.
How difficult is it to prosecute a case like this, especially with multiple victims?
It can be very difficult to prosecute child sex abuse cases. One of the things that often happens is this is a very sensitive topic. This is a very sensitive thing that's occurred to these children. And ultimately, it can be embarrassing. They may not want to cooperate or go forward. And their testimony is required in these sorts of cases. So these children have to testify about what happened to them. If there was hypothetically vaginal sex that was incorporated in this, they're going to have to get on the stand and discuss those things. And it's not always easy for children to do. I've seen children do it. I've had children do it in my experiences, but they can be very difficult. Oftentimes, what can also happen is the child can be cooperative, and then as they're walking into the courtroom, they're so afraid that they don't want to go in and they don't want to say anything. So you never know what can happen, and until the child is up on the stand at a trial and ultimately having to be confronted by this defendant, anything can happen, and hopefully that they can seek that conviction. But you just never know until things are said and done.
Well, in your opinion, with all of your experience, what legal defenses could sellers' attorneys potentially use in a case like this?
It's going to be pretty difficult to come up with a legal defense on a case like this. Her defenses are either going to be A, she didn't do it, or B, if there's an strong enough allegation and supportive evidence that she did do it, then something that would negate one of the elements of the crime. If, for example, there's a required culpable mental state, but she has some type of mental health disease or defect that would negate what that culpable mental state is, they may be able to attack it from that point. But I think the first things first, the defense is going to have to probably say, I didn't do this. Now, how are you going to say that when you have a number of children that are coming forward with this? Also, we don't know what sort of evidence they have as of yet. They can have video footage. They can have conversations between the defendant and these children about these acts and activities. So it's going to depend also on those things.
Now, the state has mentioned more potential victims coming forward. How does that impact the prosecution's case?
What can often happen is that, and I do believe there may have been an indictment in this case. If there has not been, I expect that there will be an indictment forthcoming. And just a caveat to that, oftentimes when criminal charges are brought, they may be brought in the form of what we call a felony complaint. That is a pre-indictment accusatory instrument that's brought against an individual. What happens is ultimately the prosecution will go forward in grand jury, bring about an indictment. If they've done that and there are additional victims that come forward, they can file what we call a superseding indictment and add those victims into this prosecution, or they can try them in a whole separate case. So it's going to depend on what the prosecution team decides to do.
Now, this case involves a female suspect, which is a little, less common in child sex crime cases. Do you think there is a difference in how the public and legal system view female perpetrators versus male perpetrators?
I think that the legal system and oftentimes in the public we view female perpetrators as less aggressive. I think oftentimes what they're viewed as is there's more of a question of whether this person committed this act or not. And oftentimes, unfortunately, people joke about the fact that the defendant is a woman and, make comparisons between that and children and, other inappropriate comments when the defendant is a woman. But under the eyes of the law, she should be treated the same as she would if she was a male, and the allegations are the same. So, I'm starting to see more and more that more women, particularly teachers, are being charged in these cases. I've seen an influx of these charges with respect to women in the past couple of months, and I think we're going to be seeing it more and more, unfortunately.
Well, it's interesting that you say that. Do you think, female offenders tend to receive different sentences than male offenders for similar crimes?
In my experience, not as much as you would think. I think that ultimately the way the courts view it and as attorneys we view it is that at the end of the day, this even though she's a female, this is someone that was responsible for the care of these young children. She was responsible to make sure that they were safe, to teach them, and to do her job, and to ultimately allegedly violate that role and essentially have sexual intercourse with these children is just as bad of a violation in our eyes and under the law as it would if the perpetrator was a male. Again, I think that oftentimes people will view male perpetrators as more aggressive because they are men and because they're more generally masculine, but that does not absolve the responsibility and liability just because she's a female.
Well, are there any common patterns in cases where women are accused of child sex crimes?
It depends on what you mean by common patterns. Particularly in more recent times, we often see that they come in the form of a teacher-student relationship. I would say one of the patterns is that there is a relationship between the defendant and the victim in these cases, and there's often a relationship that is built around trust, and that trust is ultimately broken by the alleged perpetrator. And then we have these situations where children are engaging in sexual acts with these adults. So the pattern is that there's a relationship of trust, whether it's a teacher, whether it's the friend of a mother of a friend or an aunt or anybody else. Those things certainly come into question, but we're seeing a lot of teacher cases right now.
Well, let's start from the beginning, how we got here. How do law enforcement agencies typically gather evidence in child sex crime cases like this one?
So if this was an incident where we have a child disclosing, such and such touched me or raped me or penetrated me last night at a slumber party, then somebody that's responsible for that child or law enforcement will take that child to the hospital to perform a rape kit. Unfortunately, it's a little different for male children because of the anatomy aspect of it. But ultimately, that child is taken to the hospital, male or female, if it's close in time. A rape kit or an evaluation is taken place, and law enforcement begins their investigation and interviewing that child's parent or caregiver to establish a timeline and to establish the acts that have taken place. If it's something that's more further in time, maybe something that was alleged a year ago, that child will disclose. There will still be, a forensic interview that takes place with that child, which is an interview by law enforcement, social workers, attorneys, things like that, so that they can establish the alleged facts of the case to see what can be charged.
Yeah, and I was just about to mention the crimes allegedly occurred between 2018 and 2021. How does the time gap affect the case?
I don't think that it's going to affect the case significantly. With particularly child sex cases, we often know that children don't disclose immediately. It's very, very common where we see children disclose years later. Or, say, for example, a parent might go in their child's cell phone and discover this inappropriate conversation between them and their teacher. So it's not uncommon at all. And I think because we're only coming off the back end of maybe 7 years from the allegations or somewhere around that time frame, it's still close enough in time that I think people are going to still view these victims as children, even though they may be 17 or 18 at this point, and they're still going to prosecute it as such.
Now, prosecutors have said that some of the victims were as young as 12 years old. How does the legal system protect child victims throughout the trial process?
So one of the things that will happen straight out the gate once the defendant is arraigned on a case is that an order of protection will be issued in favor of the victim, no matter how that individual is. And sometimes there are orders of protections that are issued for their family members or their parents to ensure that the defendant is not communicating or reaching out to that child, to ensure the integrity of the prosecution and to keep that person essentially safe from any communication, any visitation, any tampering with as the case continues to progress. What also can happen is that there's sensitive information, then the prosecutors will seek what we call a protective order to refrain from having certain sensitive material on behalf of the victim disclosed. So if, for example, we have a situation where, a child has tested positive for a sexually transmitted disease, that may not be disclosed immediately in the moment. There may be a protective order sought because of that. So those are the things that can happen.
Let's talk about the potential long term impacts. What kind of long term impact do child sex abuse cases have on victims, even beyond the courtroom?
These things unfortunately stay with people for the rest of their lives. And so the hope is always that, these young people will persevere through the situation. And as they grow older, kind of change the narrative. But oftentimes we unfortunately see, abusers have often been abused at some point in time. So there's this caveat that we want to ensure that, they're taken care of with mental health services, their physical health is intact and up to par, and they're really truly taking care of themselves so that as they continue to grow older, they can take care of themselves, lead productive lives, and ultimately not become some of the people that have ultimately hurt them as well. I mean, that's not to say that that's the case in any sexual abuse case, but oftentimes that can happen if not treated correctly or appropriately through therapy and other means.
Now, we touched on this a little bit earlier, about some victims, they may get scared in the moment, they don't want to testify. What happens if a victim decides not to testify or wants to withdraw their statement? What does that mean? What would that potentially mean for this case?
What that would mean for this case is that the charges, unfortunately, would probably go away because this individual is going to have to testify about the acts that took place between them and the defendant. They're going to have to get on the stand and be descriptive of that. With prosecutions, the prosecutor has to prove each element of each offense beyond a reasonable doubt. So when we're talking about this statutory rape charge, for example, there has to be proof that the individual was 15 years or less at the time. They're going to have to testify about their age, and they're going to have to testify about the sexual conduct that took place. If it's vaginal intercourse, they're going to have to talk about that on the stand in front of a courtroom of however many people. If they change their mind and they don't testify to those things, then unfortunately the government will not be able to prove that beyond a reasonable doubt, and there will either be a dismissal of the charge or a not guilty plea or a not guilty verdict that would come back by the jury.
If this does go to trial, what challenges do you foresee for both the prosecution and the defense?
Well, for the defense, the challenges are going to be that how do we get around this evidence? How do we get around the fact that we have, four young people who are all saying similar things about our client? That she engaged in this conduct, that she had vaginal intercourse with them. Where did these things take place? And the evidence. And prosecutors are certainly not going to bring about a case of this magnitude without the appropriate evidence. And again, we have 80 counts here. So there was enough evidence to substantiate those 80 charges. So that's certainly going to be an issue and a hurdle for the defense. Not only that, but we have a case where it's now high profile and in the media. The charges are so heinous that how do we get a fair and impartial jury to actually listen to the evidence and not view the client as guilty already because of what they've heard? The challenges from the prosecution end are going to be ensuring that the victims are still willing to cooperate, come forward, and that they give the same testimony consistently as they've told it from the beginning. As cases, continue on years on end, stories may change. People may not remember certain things. The defense is going to attack that. And the difficulty for the prosecution is going to be ensuring that those things remain the same to the best of the witness's ability.
Could public perception impact the outcome of this case?
Absolutely. We hope that, when we have a trial, we get a fair and impartial jury. We want to ensure the integrity of the prosecution and the trial and making sure that people understand that until a person is found guilty, they are deemed not guilty. As a person sits at their table throughout the trial, you can hear the most heinous offenses, the most heinous acts and allegations against that person. But until that trial closes and closing statements are over and they're charged by the jury, they have to find that person not guilty until they get back to that court or to the jury deliberation room and start to deliberate. At that point, once they have those conversations, piece the evidence together, then they can find that person guilty if the evidence supports that. But the danger, again, is that a case like this that's so heinous and high profile in nature, people may want to convict just off of the strength of what the charges are, and the charges are not evidence.
And I have to ask, if you were handling this case as either the prosecution or the defense attorney, what would your strategy be?
I think the important thing here, is to go through the evidence as a defense attorney. One of the things that we always do, at least in my office, in my representation, is we always do our own investigation. Just because law enforcement has, their evidence together doesn't mean that we don't have our own evidence to obtain. We need to interview witnesses. We need to be viewing these forensic examinations and all of these sorts of things so that we can ensure that things are appropriate, that we're attacking things that, they may not be aware of. So those things are all important. And from the prosecutor's perspective, or as a former prosecutor, just ensuring the integrity of the case and ensuring that, the testimony is the same, that the witnesses are being truthful and open and honest. And this may ultimately come down to, is a plea appropriate in this case? What that plea would look like. Is it something that would benefit both sides because putting these children through a trial or the exposure that she would face with life in prison may not be the best thing for both sides. So they both may want to have a sit down and decide, how far forward is this case going to go?
Well, great. This is definitely something that we will be monitoring closely. Thank you so much, Safa, for joining me today.
Thank you, Kennedy.
We reached out to Sarah Sellers' attorney for comment, but did not immediately hear back. Her bond is set at $2 million, and we're working to find out how the alleged victims are tied to Sellers and how the allegations were brought to police. The Brunswick County Sheriff's Office says anyone who has any other information about Sellers' alleged crimes should come forward.